Breaking news. Welcome to today's headlines. Hill Health. Court fixes date to rule on Kanus' request for DSSDG to give oral evidence. Hill Health. Court fixes date to rule on Kanus' request for DSSDG to give oral evidence. To my dear listeners from wherever you're listening from, please stay tuned as I read today's news. A federal high court, Abuja, on Monday, fixed March 16 to rule in a motion filed by leader of the proscribed indigenous people of Biafra, IPOB, Nnamdi Kanus, for the Director General of the Department of State Services (DSS) to give oral evidence on his state of health. Justice Taiwo fixed the date after counsel for Kanus, Maxwell Okpara, and lawyer to the DSS Idowu Awo presented their argument for and against the motion on notice. The news agency of Nigeria NAN reports that Kanus, through his lawyer Okpara, had in a fundamental right enforcement suit marked FHC ABJ CS 1585/2021 sued the DG of DSS and the office as first and second respondent respectively. He also joined the Attorney General of the Federation as third respondent in the suit dated and filed December 13, 2021. Okpara had alleged that the health of his client was deteriorating in the DSS custody, among others. At the resumed hearing, Okpara filed a motion on notice dated February 14 and brought pursuant to Section 116 of the Evidence Act. He argued that there were conflicts in the counter affidavit filed by the DSS and that only oral evidence of the DG and Kanus could clarify the issue. We want to call Kanus and Director General of DSS to testify, he said. The lawyer said other relevant processes had been filed to raise one question: whether the court could transfer the matter to general cause list to enable it hear the matter. He informed that though the first, second, and third defendant had filed their counter affidavit, he had filed a reply on point of law. We urge, my lord, to allow the parties to call the oral evidence in this matter, because the applicant complained that a quack doctor from DSS has taken his blood sample for about 20 times without bringing forth any medical report, he said. He urged the court to grant the application, but Awo disagreed with Okpara. He argued that while the judge had powers to call oral evidence of parties, Kanus' lawyer had not shown how the doctors attending to his client were doing quack work. He further argued that merely stating that the medical doctors his office assigned to attend to Kanus where quacks did not amount to conflict. It is important to note that the applicant has not denied the above assertion by the respondent, neither has he shown by material particulars that the listed medical practitioners are quacks. The onus lies on the applicant via a further affidavit. He said he prayed the court to discountenance the application. We humbly urge that the application is thrown away and let us go into the substance of the case, he said. In the counter affidavit dated February 24, Awo argued that it was a common knowledge that Kanus was currently standing trial on 15-count charge bordering on terrorism before a sister court. He also argued that it was a common knowledge that Kanus was earlier granted bail by the trial court presided over by Binta Unyako, but he jumped bail. He said he was arrested and rearraigned before the judge. I always said that there was no court order in existence anywhere, which is to the effect that applicant, Kanus, should have unrestricted access to his personal physician while in the facility of the first and second respondent. If there is such order, applicant has the option to produce same in a further affidavit. He said that refusal to grant this application will not prejudice Kanus' case in any way. The AGF's lawyer, Simon Enoch, also corroborated Awo's submission. He said